Olá a todos, muito bom dia. Espero que me estejam a ouvir. Penso que está tudo a correr bem. Meu nome é Nuno Monte, trabalho no departamento de marketing da IFE by Abilways. Em primeiro lugar, quero agradecer a vossa presença. Hoje vamos falar da importância de estar em compliance com o RGPD. Ao meu lado tenho a Jennifer, Business Developer Manager da Privacy, que colabora em conjunto com a Karen Lawrence, que vai falar sobre o tema. A Karen é fundadora e CEO da Privacy e autora do livro Hands-on Guide to GDPR Compliance. Este webinar vai ter a duração de cerca de 30 minutos, sendo que no fim vamos ter um período de perguntas e respostas. Solicito que as perguntas sejam colocadas através do menu de questions que tem do vosso lado direito. A Jennifer irá então depois ler as perguntas, traduzir para a Karen as que tiverem em português. Peço-vos também que quando as perguntas forem colocadas, que deem alguma indicação na pergunta que querem que o vosso nome ou a vossa identificação seja revelada quando partilhamos a pergunta. Vou então agora passar a palavra à Jennifer. Olá Jennifer, bom dia.
Olá Nuno, bom dia. Olá, bom dia a todos. Como o Nuno disse, eu sou a Jennifer, por parte da Privacy. Eu estou aqui no nosso hub em Lisboa, mas Privacy é uma empresa de origem sueca e nós temos a nossa sede neste Estocolmo, onde também a Karen está hoje. Eu vou ser aqui a moderadora para as perguntas e respostas, por isso, podem, como o Nuno já disse, podem perguntar em português, tanto como em inglês, e depois faremos as perguntas ao final à Karen. Eu acho que é só isso que vamos dizer agora.
Sim.
So, Karen, very welcome to the webinar. The stage is yours.
Okay. How many are we?
We are around 40.
40.
Something.
Yeah.
Oh, excellent. Welcome. Okay, so basically I decided to, when I got requested to do this webinar, to look at the basics of GDPR compliance. And it's not like the basics when you're sort of saying, okay, this is like starting ABC. It's to do with, if you don't get this right, you don't get anything right. And there is actually three things that I wanted to just cover today. And I'm going to be speaking for 20 minutes on these three things. So it will be very fast, but then you will have time to ask some questions afterwards. So let's get started. Now, the three aspects that I want to actually talk about is 1, privacy dilemmas, 2, getting a common language, and 3, privacy risks. And why these three? Because 1, privacy dilemmas actually impact decisions, business decisions made, which may not be understood by all why a decision is made, and often undermining underneath the decision has happened is because of some kind of dilemma. And if you understand these dilemmas have happened, then it basically enables you to manage it in a smoother way. To avoid conflict. Now, the second one, the common language, a common language. One of the biggest challenges in organizations is that privacy compliance basically, and actually on the back of the book, it actually states that it is the 6 words in the GDPR, data protection by design, by default, that have actually extended the reach of privacy compliance out of the legal function into every single business function. And the challenge has been that the rule book, which is the GDPR, General Data Protection Regulation, is written in a legal way that is not understood by the business. And the business speak a language that's not always understood by the legal guys. So it's really important to get a common language that everybody understands. And that's what the second point's about. And the third one is privacy risk. And privacy risk is extremely important to understand because if basically it's a good scoping parameter, first of all, for the role of the data protection officer. But also, if you get this wrong when you are trying to become privacy compliant, you will get everything wrong. So here we go. So privacy dilemmas. Now, the most fundamental dilemma that we are all faced, wherever we are and whatever we're doing, is that whenever a conflict arises between privacy and accountability, people demand the former for themselves and the latter for everyone else. What this means is that we want to have privacy for ourselves, but not for everyone else. And this fundamental dilemma underpins all of the other dilemmas that we're going to look at now. Freedom of speech versus privacy. Now, in order for us to have a democratic society, in order for democracy to work, there must be freedom of speech. The press must be able to be the voice of the people. However, freedom of speech can also conflict with privacy. So freedom of speech is a human right, and as is privacy, a right for a private life, is also a human right. So this means that sometimes we find, for example, in countries, if you take Sweden, for example, where I'm sitting at the moment, in fact, freedom of speech is so strong that it has priority over privacy laws. And this creates problems whereby in Sweden still, our personal data, even my personal ID and my address, it's all public data. And this is mainly, I guess you would see it mainly in where, you know, celebrities, they are being hounded by the press, and their right for privacy is at the cost of freedom for speech. So anyway, this is one of the main ones that's actually backed up with privacy laws and with freedom of press rights. Societal function versus privacy. Now, in order for society to function, personal data must be collected. And so, you know, your kids go to school, your kids' personal data needs to be shared with the school, the doctor. Your personal data needs to be shared with the doctor. With your work, your personal data has to be shared with your employer so that you're able to do your job and able to get a salary. So it's impossible for society to function without sharing personal data. Personal safety versus privacy. Now, as we're going through our lives, how important personal safety is often changes. When we have children, we become more protective. When we don't, maybe we're a little bit more laid back. But the fact is, if there is some kind of attack against our family, if we take a terrorist attack, for example, if we take what happened in New York, we had a terrorist attack in Sweden not long ago, and there's in Spain and in France. And basically, when these happen, it means that we as individuals will forfeit our privacy in order to be safe. And this could be the installation of, for example, surveillance cameras. Security versus privacy. Yes, in order, if you're using if you have a telephone and you'll be using your biometric authentication, you are sharing sensitive personal data in order to access your telephone, in order so that your telephone can be secure. And basically, this is a dilemma to share in order to feel secure. National security privacy, and we touched on this already a little bit when it comes to personal safety, and this is basically this got a lot of publicity with the Snowden disclosures, whereby they collect your data, personal data, in the public interest in order to make us safe. And this is the final privacy dilemma that we have. Oh no, we have one more: convenience versus privacy. And this impacts every single one of us. You want to find your favorite coffee shop, and so you get it up on your app. You're using GPS, it's using something called location services. And we find it difficult, in fact, not to share personal data, and many of us will make a choice that we prefer to have the convenience of a telephone, a device which has these functions, which collects our personal data and our habits at the cost of our privacy. So let's move on now. So basically, with what I mentioned to do with having a common language. Now, what we talk about is something called the privacy Esperanto, and we sort of basically learn people to speak these there is 8 privacy principles, and they were defined by the Organization of Economic Cooperation Development in 1980, and they were actually based upon their information practices from the US that were created in 73. So it has actually become the lowest common denominator in privacy globally, which means every country which has a privacy law, not all countries do, but every country that does, has basically founded their privacy law on these 8 principles, and it's extremely useful. One is to get a common language across the organization, but also to have a lowest common denominator. If you have legal teams spread over different countries, and some are in the EU and some are not, and the EU does have the strongest privacy law globally, it means you can actually start at this level and work your way up to come to an agreement on best practices within the organization. So the first one is collection limitation principle. Collect only what is needed for the purpose, and if necessary, get consent. Now, a technical implementation of this could be, for example, a form on a website. Somebody's going to buy a book and they need to write in their name and address, and you avoid the free text fields and you use drop-down boxes and click boxes. And this is a way to prevent people from sharing more than what they absolutely need. But there's a whole load of examples of collection limitation in marketing when they're doing surveys and this kind of thing. Tricks on how you can reduce the amount you can collect before you actually need to. So then you come on to number 2, which is data quality principle. Now, basically, we as people during our lives, we change. Our personal data changes. We move house, we change names, we get married, we have kids, we change job. And basically this principle states that personal data, it is in the GDPR, it actually states, because of course the GDPR, just as other privacy laws globally, is founded on these 8 principles. It states that the controller, and the controller is your organization, when they are collecting and they're processing personal data, it is the controller that determines the means and purposes of the processing of personal data, that the controller needs to ensure that the data quality is upheld, and this would include responding to rights of the data subject, which we will cover a little bit later. Purpose specification principle. There must be a specific purpose for the collection of personal data. If there is no purpose, you should not be doing it. Use limitation principle. Now, this is about you have collected personal data for a specific purpose, but then it's how you use it afterwards. So for example, let's say that you buy a book on Amazon.com. You share your personal data enough in order for your book to be delivered to your home address, which is your name, your address, and the name of the title of the book. So that's the purpose, to purchase a book, to have it delivered. Now, in use limitation, this data should only be shared where it is absolutely needed within your organization in order to fulfill the purpose. So in this example, it means that you actually have to share the data internally to the delivery department, and maybe they use an external organization like DHL to deliver your book, but that is the name, the address, and the title of the book. Now, there could be a secondary use. Well, there would be a secondary use, because in order to pay for the bill, pay for the book, you need to, you would use your credit card, and then that data is needed for the purpose, but then that data needs to be kept for longer than the actual purpose. So for the delivery of the book, one could argue that after the book has been delivered, the purpose has been fulfilled and the data is removed. But you have something called bookkeeping laws that you need to be compliant with. And these laws take priority over what is stated in the GDPR. And in Sweden, for example, financial data needs to be stored for 7 years. So this is use limitation. Now, let's say when you're buying this book, it drops a cookie on your computer. And this is not a part of the original purpose. And for that, a separate purpose needs to be created for marketing, in the respect that it is put a cookie on your computer in order to enhance your user experience, quote unquote, or whatever marketing's doing with it. But the way that I deal with it is be very specific and have a separate purpose for marketing and what it is for the purchase of the book. It's easier to manage this way internally. Security safeguards. Now, the security guys know about this, and this is covered under Article 32. And basically, sufficient safeguards need to be implemented to ensure that personal data is protected from unauthorized access, unauthorized modification, destruction, etc. Individual participation. Now, the thing that is unique about the GDPR is that it has turned the whole thing upside down when it pertains to the rights of the individual, so the rights of the data subject. So the data subject sits right in the middle, and basically what we can say is the data subject owns their personal data. They have rights pertaining to access to their personal data, the quality of their personal data, as already stated under data quality principle, the right to have it deleted, or the right to be forgotten, as it's more commonly referred to. And the controller has a responsibility to respond to these rights. This is actually covered in its own articles in the GDPR between Articles 15 and 23, but it's woven all the way through the GDPR. Now, the rights of the individual are not absolute. For example, an individual cannot request that their personal data is deleted permanently if it turns out that there is a law that requires that data to be stored for a longer period of time, like bookkeeping laws, as we mentioned with the Amazon.com example. Openness. There has to be absolute transparency pertaining to the collection and the processing of personal data. And openness is also to do with the fact that the organization needs to be transparent with the data subject. They need to be transparent with the supervisory authority. So this would also include the requirement for breach notification, Articles 33 and 34. 33 requires that if there is a personal data breach, and notice I say personal data breach, not just breach. There is no law saying that you have to report a breach. And there is no penalties if you lose your intellectual property or other data. It is a personal data breach upon which a notification to the supervisory authority needs to be made within 72 hours if it is shown that it will present a risk to the rights and freedoms of the individual, and it needs to be made to the data subject unless that data is considered to be unintelligible, for example, encryption. Accountability. Now, the controller, they need well, let me just make this simple. If you have done all the other 7 principles perfectly and it's running like a dream, if you have no evidence, if you have no accountability, if you don't have a DPO, you don't have somebody responsible for it, it's worth nothing. If you don't have it documented, if you don't have it evidenced in the GDPR, then it doesn't mean anything. So accountability is extremely important. Now, we'll move on to privacy risk, and I think I'm going over time, so I make this quick. What's really important is that privacy risk people often say it's the risk of harm to a person and this kind of thing. But we need to be clean on this because it's really important, especially when we're looking at how the regulation is translated into different languages. Privacy risk is the potential harm, quote, the rights and freedoms of the natural person, unquote. Now, think of it this way. Let's say there's a young girl, she's online, or maybe her boyfriend's taken pictures of her and he posted online. Now, basically, this will present a risk to her rights and freedoms. And this is the way that we need to think about it. It will actually, in the worst case, it will cause the individual to kill themselves or to do some real harm to themselves. And this is, what I find is that people keep talking about, yeah, it's a risk of harm, but it's not just that. It's to do with, you know, you can't go out of your house because you lose face, or there's something, you know, there's something else that stops you being free. Because basically, it's like I said previously, privacy is a human right, and this law is actually driven by the right to a private life. Now, one of the biggest challenges for a DPO is the fact that they are, because data protection by design by default is extended out of the legal office into every business function, it means that it's everywhere. It's within personal data, it's in the whole, every part of the organization, every employee is collecting and processing personal data one way or another, whether they know it or not. And the DPO, when he's looking at his role or her role, in order to keep it clean, they can see this as the scoping parameter, because privacy risk is purely about standing in the shoes of the data subject. And this is where we get to, how do you define what is your privacy risk appetite? You know, in an organization, if you're looking at security, you spend so much money on trying to prevent, you know, to stop systems being flaws in systems. You put patches on them, you put virus scanning on computers, and you spend enough money until you get to a level where you sort of say, look, there's only this much risk and it will cost this much to fix it. So we have to accept that risk. And it's the same with privacy risk. However, the controller or the DPO, the role of the DPO is they stand in the shoes of the data subject when they are saying, what is our privacy risk? Because they can't go out and ask every data subject, what is your privacy risk? So this often causes conflicts in organizations with the corporate risk team. And we get back to the dilemmas that I started with. Because the DPO is standing in the shoes of the data subject and everyone else is thinking about corporate risk, what will be the brand damage? Of course, a privacy risk can lead to brand damage, but we get to situations like, I'm not sure how it is in Portugal, but in Sweden, for example, when you report a breach to the supervisory authority, it becomes publicly accessible data, which means the corporate risk team may say, we don't want to report it yet, because we're not sure it's actually a risk to the organization. Well, they feel that it's a risk to the brand. And the DPO is saying we must report it because it is a risk to the individual. And this takes us back to the dilemma, freedom of information, which is what has happened there, the freedom of information, publicly accessible data, versus, you know, what is right in the shoes of the DPO versus privacy. Okay, what you just got is a little bit of an insight into the sort of material we cover in the Certified Privacy Practitioner. We have two awesome guys delivering this in Portugal. There's João, well, I call him Cool J. He's the coolest legal guy I've ever met in my life, and I'm not very good at pronouncing his Portuguese name. And then there's Sandra too, and so Cool J is a legal guy, and Sandra is she's a compliance guy. So, and they are an awesome combination. So if you have any questions, I think we can open the lines now, Jennifer, if we're not running out of time.
Yes, Karen. Thank you for your presentation. We actually already have a first question here, and is from someone, a lady who's working in the health sector, and they are asking, because they are covered by the professional, what do you call it, sigil, for doctors.
Yeah.
And what is actually, what should be the one to use for them? Is it the GDPR, or is the doctor's own sigil higher, so to say?
Well, is this
when they're talking to the client or the patient?
Oh, it's confidentiality, yeah?
Yes.
Yeah. Well, that confidentiality is very strong, isn't it, as a law? So basically, when there is a clash between GDPR and another law, normally it is the other law that prevails, which is a problem in Sweden with freedom of information, for example. But in that case, it is very good because it is stronger. Does that answer the question? I don't know.
I think so. What would you say, the person who asked the question? Are you satisfied? Yes, she's satisfied. Good.
Yeah.
And we have I was thinking of a second question here. What are the main, when you're talking about the dilemmas, Karen, and the challenges for the DPOs, what are the main dilemmas you see in the DPO everyday life or for the privacy team to actually reach compliance for an organization or a company?
Oh God, there's loads. In the really large organizations, I see a lot of challenges with the responding to the rights of the data subject. Now, there's one thing, I already mentioned something, and that is to do with when there's a data breach and getting it understood. The fact is, you need to be looking at it from the shoes of the data subject. And that's really important because I actually know already 2 DPOs that have resigned due to conflict internally. And I'm sure if they'd done our training first, they wouldn't have resigned because they would have realized, oh, this is a dilemma. I think you need to be very diplomatic to be a DPO in order to understand that you are standing in the shoes of the data subject. And I am actually sitting as the DPO for, I don't know, 5 or 6 organizations here in the Nordics. And I say to my clients, look, I'm going to disagree with you because I'm standing in the shoes of the data subject. And they normally laugh because they understand that I have to do that. That's my job. And this is why the role in the GDPR is stipulated. It has to be independent. And you're not allowed to sack your DPO either for doing their job. But anyway, in order to get back to the question, one of them is to do with the reporting of the breaches to get some consensus on that. And the DPO needs to be independent to be able to push that through. And the second thing is that I find that responding to the rights of the data subject is extremely challenging if you have not done your privacy awareness training in a good way. For example, I've had to sort of say, okay, look, is there any personal data? I'm going through all the I need to go to the application owner. You don't have the. That means you need to sort of say, okay, a data subject has made a request through this channel. Let's sort of say it's an insurance company and it's a car accident or it's pet insurance or something. And then you go to the application owners and you sort of say, okay, do you have, we need some personal data. And, insurance, they're normally pretty good here in the Nordics, but in other industries, they may come back to you and say, we don't have any personal data. And you know that there is personal data there. So you have to go back and say, look, don't you have any of this data, ABC? And they say, well, yeah, but that's not personal data. And then you realize that the privacy awareness training hasn't been rolled out, or if it has been rolled out, which is actually the case in one organization, it's been rolled out using legal language and nobody understands it. So they didn't get the thing about personal data can actually be your cat or your dog. It could be the bread that you buy from the supermarket if you use a store card.
It's good to measure somehow that the employees or the full organization understands what personal data is.
Yeah, what is personal data? What is processing? Personal data is any data linked directly or indirectly to a natural person. What is processing?
Karen, sorry to interrupt you, but to go further, we have another question here which links a bit to this with the personal data. It's from a man called George, and he is developing software for companies, and he says there's always some kind what do you say?
No.
A doubt, sorry, if the protection of personal data is data from companies, clients, and suppliers, or just for the individuals.
So what's he doing again? He's developing software, yeah?
Yeah, he's developing software for companies, and there's always the doubt if the data protection should cover the company data, including the clients and suppliers, or just the data of the individuals.
Yeah, well, it covers, you know, if I understand the question correctly, a supplier has is a human person too. So personal data covers each of us with our personal identity and also our business identity. I hope that answers the question.
Yes. So to say, for example, if privacy is a company, it would cover, for example, me, Jennifer, or you, Karen, but not privacy as entity privacy.
No, not when it comes to, because we're looking here, when the GDPR was actually written, it was basically needing to balance the right to privacy of the natural person, and the natural person is from the moment of birth until death in the EU, and with the organization, the societal function that I mentioned as one of the dilemmas. So it's to do with individuals. It's the data subject, it's residents of the EU. And it could be your business email address, but it's also your personal email address. So it's your personal email address, but also your business email address. It's your business, it's your job title. You know, I am CEO, whether I like that or not. I'm a terrible CEO, incidentally. I'm a great at my stuff in privacy, but still, my job title is CEO, and that is my personal data.
Very good, Karen. Then we go to another question, which is regarding HR. So, hello, we are HR consultants, and for us it's very important to know the main GDPR sensitive issue related with recruitment and selection process management, applicants' personal data management. Thanks in advance.
Oh, yeah. So there's two. What I'm normally splitting up. So you've got the recruitment, and you got the actual recruitment process, and you've got the employment when it starts, where you say I'm going to employ this person, and you sign a contract with them. But with recruitment, there is two legal bases being approached, and it's either consent or it's legitimate interest. Clearly consent is preferable, but for that you need to be able to capture the application before they share data. So if they upload it to a portal, for example, if you have a recruitment portal, you can have a consent tick box, but not every organization has the luxury of having a portal where their potential employees can upload their application for a job. So HR is really a big area, and it's lacking very much at the moment. It's like for Privacy AB, our company, when we recruit people, it's like, how do we do that? You know, well, when I looked out there on the market for companies that we could use, that would have a portal that we could use for applicants, so they were not allowed to send, because you should not allow anyone to send emails to you for jobs. You should send them through a portal. But in practice, this just doesn't work, because there are no solutions out there that are designed for SMBs. You need to be at least like 200 employees, at least what I found. So this is why legitimate interest has become a secondary option for using recruitment. But I would say the tidiest one is consent. I hope that's answered the question, but it's a really big question.
Was this okay, the human resource team, the response? Yes.
Yeah, we need more time to talk about this, because I've been working so much with, you need to do risk data protection impact assessments on the HR, you've got the recruitment part, and then you've got the actual, the employment part, which is separate.
Yeah. So, is there any other questions now? See, we're running a bit over time. So if there's anyone who wants to have the last question, feel free to write in the question field. Or if you want to discuss more closer with Karen, she will be in Portugal next week, in Porto, if you're in the northern area. And we can also keep you updated for upcoming webinars, I guess. We have someone here who's saying we're okay. Thank you so much for the opportunity. Very nice.
It's the same team.
Yeah, it's also the human resources team.
Good luck.
Yeah. You want to say a final word, Karen, to the audience?
No, well, I'm flying into Lisbon, I think, aren't I? We're going up to Porto for a couple of days, and we're coming back again, so we'll be in Lisbon too.
Mm. Oh, we do have another question. Actually. Still treating the human resources. How are we supposed to do with the collection of photos or images of the workers or collaborators in events?
Yeah.
Company and how to use that. Yeah. Should we always ask for consent?
Yeah. Yeah. Oh no, something else I need to add about recruitment as well is that, of course, it's the employment law that normally is stronger in that you need to keep the, you need to keep the CVs for even longer than the actual purpose. If they don't get the job, it may be you need to keep them for as long as 2 years in order to, if there's some things in the employment concerning discrimination and that kind of thing. Yeah, with photos and things like that, it's like we get back to the collection limitation is to collect what is absolutely necessary for the specific purpose. And yeah, it depends. I would say photos is part of the it's not going overboard with the CV. So I wouldn't personally have a problem with that. I like photos on CVs personally, so I have a personal dilemma there.
And photos at company events, if we hold an event and we take a photo close up of me, for example, or of Nuna,
yeah,
the crowd, how can we use them, or should we use them, or should we ask consent from?
Yeah, no, basically we get to something called is there a reasonable expectation? You need to ask permission to do this, consent, and people, if they're coming to a conference, they may actually agree to that. And of course what we do, Jennifer, is we say if you don't want to be included in pictures, we put them on the left side, and those that are okay, put them on the right side. That's how we deal with that. But at the same time, you can sort of get into the legal discussion on, what is legal, what is an expectation. If a photo is taken, what is the expectation for that afterwards? But no, you should not reuse. It's anything, including photos, and you should not use it for outside of the original purpose for collection.
So, for example, if we hold a big seminar or a big company event, it would be nice to take some photos to actually show it afterwards, because it would be part of the marketing.
Yeah.
But how can, if it's more than, for example, 10 or 20 people invited, how can I structure that or manage that?
Yeah. What you could say is that in the invitation that there will be some photographs taken, and it will be used for marketing, and there will be a reasonable expectation that that is the case. People should be given the choice to not be a part of that. That's the only thing. I would say in the GDPR the most important word is choice, and choice comes down to human rights. So so it depends.
Right.
But reasonable expectation is the magic words there. Is there a reasonable expectation? It's like, for example, if I make my photo available on Shutterstock or iStock or somewhere, Is there a reasonable expectation it will be used somewhere else? If somebody takes my photo to I'm stood outside and I'm at a conference, and I would expect them to use it in the context of the conference, but I wouldn't expect my picture to pop up somewhere different. So this needs to be taken into consideration. And for this, it's always good just to consult with your legal guys.
Very good. So I think that was the final question here. You want to say a final phrase, Karen, before closing?
Good luck. Keep it small. You know, whatever you're doing, keep the scope small. Take it in small bites. It's a big elephant, and take a bit at a time.
Is it
Legal?
Is it legal to implement the application at the phone, at your mobile phone, which is offered from the company that controls the localization and content on the phone, on the mobile phone?
So is it legal to take location data? Is that what they're saying?
Yeah, well, if we implement an app on our phone that is supplied by the company that controls geolocalization or content on the phone.
Yeah. There needs to be consent some way. Well, there's two things really. Basically, it depends whether you're going to use contract as the legal basis. There's actually 6 legal bases for this, or you're going to be using consent. If you know, for example, if you're going to use an app to call a taxi, and you've downloaded the app onto your telephone, you know, there is an expectation, there is an intention that you will go into a contract with the taxi company, and so contract can be used in this case. But if you are downloading an app on your telephone and it's something, I don't know, something else, and you're not having any relationship with the company and you're not planning to buy anything from them, it's just whether whether you have to provide consent for that, and consent has to be either explicit if it is health data, or something called unambiguous, which I would say best translation for English, which is easy, is affirmed consent. You know, downloading the app and agreeing to the privacy notice, for example. So that was a little bit tricky, but there's 2 legal bases: is either contract or consent, depending
follow up on this question here. This app is also controlled by the IT department. Is that legal?
Okay, so is it? So I guess is it an organization? They have rolled out an app. Is it to their employees?
Yes.
Oh, okay. So they rolled out an app to their employees. Is it necessary? Does it replace? Is it necessary for their job function?
We need to ask. Yes.
Yeah. And before
necessary then for the job function to be able to control the localization and the content on the phone, also.
Yeah. Well, the thing is that the employment contract will actually state that they will, you know, that their personal data is needed in order for them to do their job function. So in this case, it could be that it falls under contract. And whether it's legal or not, it's legal as long as there's a legal basis. And for this one, it will be either contract or maybe legitimate interest. I'm not sure. But consent is needed in the job if it's something outside of, you know, the actual job. Any extra personal data, it needs to be a choice there. But in this case, it sounds like it would be contract that's necessary. And yes, location data, this is legal in as long as it's tied to a legal basis. This is Article 6 of the GDPR. And the data is secured, taken care of, and the rights of the data subject are responded to. An employee is a data subject too.
Yes, very good. Is that an okay answer? The question is that also that the phone is also used for private issues or private purposes. So that means that the company could then,
well, then you start, yeah, but then you start to have issues. It's like in that app is personal data being stored in the app of the customers of that organization, which means that personal data is being stored on a private telephone. And the security mechanisms in place need to be that if a telephone the telephone should be encrypted. If it's lost, there should be remote swipe, and all the security stuff comes into play.
Yeah, because it says now that the application has also access to private applications.
Oh, okay.
This
yeah, well, look,
would be better to have one work phone and one private phone.
Yeah, because the challenge is that if you have this on a private phone, you know, and then you say, okay, we are going to have to make sure it's encrypted, but then you say if you lose it or if it gets stolen, that we're going to swipe your phone. Swipe means that everything is removed. It's not very practical if it's on your private phone. So yeah, in this case, what I'm seeing in another organization is that where we have technicians working on site and they're using apps, they're being provided with iPhones or Androids to do the installation, for example, which is separate from their private phone.
Now it's coming more question. Do we have time for one more? Maybe we can take one more.
One more.
Oh, I'm sat here. I've got nothing planned for the next 10 minutes at least.
So, do I need to get consent from everyone to have the contact details stored in my phone? Phone number, company, department? For doing my work, you say?
No. Yeah, this is I don't know how to answer this because we all have contact details in our phone, and I guess if it's mainly to do with there's two types of contacts in your telephone. You have your business contacts and you have your personal contacts. Now, your personal contacts falls under something called household exception to material scope, which means anything that you collect and process, any personal data you collect or process for household use, is exempt from GDPR. It's still personal data, but it's exempt. Now, if it's for business use, then it would come under probably Article 6F, legitimate interest. But nobody's really come up with how we deal with that, to be honest. It's just that we can't. You can't just get consent of everyone in your contact list, so it just has to be. It's required. It's a societal function thing, legitimate interest for the organisation. And what you would do is that when you're doing
partners you have for managing your business or your
when you're doing a data protection impact assessment and in your data registry, you just make sure that you have it in there. You know, that you do, you know, everybody has, in the old days, they used to have like a phone book with alphabetical, you know, listing. So nowadays it's like in a telephone, your contacts. So just that that these are actually being, you know, what is actually being stored in the telephones. So at least if anything goes wrong, at least you're sort of trying to do your best.
That's a good answer. Now
I've just seen here. I've got a
Just
cat behind me. If anyone can see, it wasn't planned. I thought I threw the cat out, but she creeped his way back in again.
That's good. So I think that's the final. Now there is someone who is thanking for the opportunity. And I think we are supposed to thank also for the opportunity. I don't know if you want to. You said your last word. You said good luck, Karen.
Yeah, we'll see you in Portugal next week.
Yeah. Okay. And we welcome you.
Okay.
Muito obrigado.
Okay. Yeah. Bye.
Thank you very much, Karen.
My pleasure. Bye.
Thank you, everyone, for participating. We hope to see you soon again.